Back now, the Senzo Meyiwa murder trial is continuing in Pretoria today. Arguments about the authenticity of Docket 375 are expected to continue. The National Prosecuting Authority says there's no merit to the docket, which implicates the people who were in the house on the night of Meyiwa's death. There's now also an issue of a court jurisdiction which might derail the trial. Our reporter Silindelo Masikane has been following proceedings in court and joins us live now with more details. Good morning, Silindelo. Quite a lot happening in court yesterday. If we perhaps start with jurisdiction, we had Tefu there arguing extensively on the jurisdiction, saying this matter does not belong in this particular court, but perhaps in the South Gauteng High Court, given that it occurred in Vosloorus, the particular incident. And we also heard the judge then saying, no, Tefu, you're going to have to bring a substantive application to deal with this matter. We won't deal with it in this fashion. Talk to us about exactly what transpired in court.
Well, certainly so. We've had quite lengthy proceedings yesterday in terms of these administrative issues around when the trial can officially resume. However, Advocate therefore, as you correctly stated, raising an objection with regards to a lengthy postponement, but also an issue around once more jurisdiction and whether the North Gauteng High Court has the mandate essentially to be able to be hearing this trial. Therefore, is objecting and saying that because the matter is being heard in the North Gauteng High Court, there are a number of issues he wants to flag in terms of the process that was followed to sanction this court to give jurisdiction. We've heard a lot of analysis around whether the North Gauteng High Court can hear these particular proceedings. Let's just take a listen to essentially what one legal expert has had to say around this issue of jurisdiction.
When a matter comes from Vosloorus, where this offence was committed, Palm Ridge would be the High Court in the South Gauteng division that would be hearing the matter in the normal course of events. But the NPA, by virtue of the head thereof, has the authority to designate in terms, I think, Section 22 of the NPA Act, to say this matter must be tried in a different division. So first and foremost, if there is such a direction, which we understand there is, then the Pretoria division has the authority to hear it. But keeping in mind that the Gauteng division consists of two courts, being Johannesburg and Pretoria, and it's for convenience that the matters are often heard in Joburg, and for convenience that it's often heard in Pretoria, because they have the same jurisdictional area in essence. So it doesn't really matter whether it's Pretoria or Joburg. But then if you take it one step further, if there is such a direction by the NPA, well, then the matter must be heard here. And then lastly, in terms of the Criminal Procedure Act, Section 110, it clearly states that if an accused has pleaded, whether guilty or innocent to the charge, and it then is discovered later on that suddenly this court is not vested with jurisdiction, it is deemed that the judge has jurisdiction to hear the matter. So this is actually a moot point. It has no bearing on the matter. Yeah. I don't see the court will entangle itself too much with these arguments, and I believe that this court is the court that should hear the matter based on that, because it was not pleaded.
All right, and then Silindelo, insofar as the docket matter is concerned, we heard Advocate Mshololo there reading out the letter from the NDPP. Can you just take us through exactly all that happened pertaining that docket and where we are now?
So when we adjourned last week, Advocate Mshololo had indicated that she wants to write to the DPPs of the North and South Gauteng High Court to get clarity around Docket 375 and why the NPA decided it was going to pursue Docket 636, which is in connection to her client. And of course, we know that she only received the docket formally last week, saying, of course, that this was prejudicial against her client and his constitutional rights to be able to craft a defense for himself, even saying that the late disclosure by the state equates to a miscarriage of justice. Also saying that she had now received correspondence, 2 letters were handed in from the NPA clarifying a document in connection with Docket 375, which purports to be some kind of an indictment, a memorandum, the state calls it, in which those in the House, it claims that they have a case to answer to, and the state then clarifying in those letters that That particular document in connection with Docket 375 has no merit and was just merely an opinion of a junior advocate within the department. But the defense is having none of it and still plans to cross-examine the state's witnesses in connection with Docket 375. And Advocate Mshololo also saying that she needs more time to be able to study this docket and is requesting a lengthy adjournment. This is where now we're seeing the two defense advocates at war with each other, really, because Advocate Tefo does not want a lengthy postponement, saying that that's going to prejudice his clients to a speedy trial, and that justice delayed is justice denied. Of course, Tefo represents accused 1 to 4, and accused 1 and 2, from what we understand, were arrested when they were in KwaZulu-Natal, and he claims that his clients have never had an opportunity to even apply for bail. And he says that if this court is going to grant a lengthy postponement, then it's going to further prejudice his clients, and he's of course looking to possibly get them released ahead of a possible lengthy postponement. So when we resume at 10 a.m. this morning, we'll be canvassing more of those issues around when heads of arguments will be filed formally in an application by Tefo objecting to a lengthy postponement, but also that issue around jurisdiction.
No, most certainly another interesting day in court, we presume. Let's actually bring in Heidi.